Hi, I'm Perry Segal. I'm the former chair of the State Bar's Law Practice Management and Technology section. I'm also the incoming co-chair of the State Bar's Council of Sections. I'm a technology attorney and litigator. And what I'm going to talk to you today about is relation to my program that I'm doing at the State Bar annual meeting, which is program 63 on the NSA and attorney confidentiality. But I'm going to speak a little bit more broadly to you because we find that attorneys really are not aware how much technology affects the data that they compile for clients. So first thing to understand is that you have to take a very broad view of what technology is and where data is. For example, it isn't even all about devices. It can just be about data that you have anywhere. People tend to think of the predictable machines they use, such as printers, computers, cell phones such as the smartphones like I have right here. But what they don't think about is that devices such as fax machines, printers are now basically mini computers. They have hard drives in them. They retain the data and it can be recovered. So for example, if somebody takes a printer and it's old and they donate it, or sell it to a reseller, that person can get that data off of that printer or fax machine, which can include confidential records. So this is what you have to think about. You have to think about electronic data, which could be the reader on a gas pump, for example. Anything that holds data. These days, toasters have circuits in them that retain data. Anything that could be relevant. The second thing to think about is how you're holding your client information. So for example, we have a lot of programs now, LinkedIn as an example, but many others that will say, you know, give us, log in and give us your password and give us access to your contacts and we'll find out who you know. Well, the problem is if you have your attorney contacts and client contacts in that list, you are technically violating State Bar ethics rules by giving away your confidential contacts. That should only happen if the client actually authorizes you to do so. Think about this in terms of something like you're in the middle of say a company going public. It's confidential. But if this client is in your list and you happen to be a firm that handles mergers or public access, then in that case, somebody who sees this may understand that you may be working on a merger. Technically speaking, that may be a violation of privacy rules. These are the kind of things that you have to consider when you're dealing with client confidentiality. But it's more than that. Do you work, for example, in Starbucks after work? And do you send emails from Starbucks? If you do, and you don't have proper protection on your devices, it may be easy for somebody to detect the documents that you send and intercept them. This can get a little bit confusing, but basically, for those who want to go do some research, you may be looking at something like a Firewall. On your personal device, your laptop, where you can turn this on, which will prevent people getting access to your laptop, for example. State Bar has many ethics opinions on this. This particular one is called 2010-579, I believe. But the idea is what it says is you will be excused from this particular provision only if it was an emergency situation in which a document had to be sent out immediately and you had no choice. Otherwise, you could be held responsible for documents that you send that you did not secure. Also, new attorneys such as yourselves, no matter what age you might be, are going to be looking to use technology, for example, what we call the virtual law office. And in this case, you again have to take provisions and protect your client data when you're communicating with somebody over the internet. State Bar also has an opinion on that. What I suggest, rather than rattling off a bunch of numbers to you, is that you go to the State Bar's Ethics and Technology page, which is easy to find, and you will see in chronological order all of these technology opinions, and you should familiarize yourself with them. Now, when we're talking about this kind of confidentiality, when we get into something like the NSA or who may be watching, things get more complicated. For example, nobody except the NSA really knows exactly what they're doing. So how are we as attorneys supposed to protect our data? Well, this is only a 10-minute talk, so I'll make it short. The key is you need to maintain the standards set by the bar. And that means taking care to protect the data under the rules of what the bar states. You do not have to be perfect. You do not have to anticipate that the NSA is watching, because there is no way to know exactly what they're doing. If you follow proper bar procedure, and you can document that you've done so, you're still going to be okay in case a breach occurs. On the other hand, if you fail to take the proper precautions, you run the issue of possibly being caught off guard and getting into trouble related to your clients. Now, something that may also come up for you, and questions I get quite often now, is mostly from very, very nervous clients and attorneys who really don't know if their data has been breached. I think the important thing to understand is that we have certain clients, for example, that will say, you know, I don't want to communicate by email. I don't even want to make phone calls. I only want to speak in person. This is not realistic for attorneys, because if that were to occur, you couldn't conduct business. It's simply impossible, especially since we're not all in the same place. So what I tell my clients is what I will tell you. You conduct your business properly. You take the proper precautions, but also understand if you did have something sensitive, let's say, for example, you instruct an entity not to email you. I have had situations, for example, where somebody forgot about that rule and emailed anyway. That is not necessarily an ethics violation or a security violation. The key is, even if that occurs, was the communication within the protection of the state bar itself in terms of the ethical rules? That's the key. So if, in fact, even if an inadvertent communication happened, but it's still within the rules, you don't have to worry too much. As far as those who might want to research further about some of this, the NSA has actually posted letters in which they addressed a letter from the American Bar Association president related to what exactly they're doing with data, and understanding that attorneys have attorney-client privilege. We also, for our clients, have Fourth and Fifth Amendment protections. These still exist. While the government may gather copious quantities of information, that doesn't mean they have some sort of open license to use it all. They're very restricted on what they're supposed to use. They're restricted as far as if they realize that they're getting data they are not supposed to have, they are supposed to ignore it. Now, I understand that that's a bit of a touchy subject, but that's what they're supposed to do. Essentially, the government is looking for terrorists. They're not looking for your clients in most cases. So if your client is not a terrorist, you're probably in good shape right there. But let's be honest, sometimes certain criminal matters may come across a wire, certain civil matters. This does happen. In these cases, I've been asked a very touchy question, which is, should I, warn my client that this has occurred or may have occurred, and tell them they shouldn't lie? This is a tough one. My opinion is, anybody who's involved in a legal action has been admonished at least once to tell the truth. If a client has chosen not to follow that, certainly the client is aware that they are in danger, that something could happen related to that information. Other experts may not agree with me, but the issue is we really can't know. So you have to do the best you can. There isn't anybody who can exactly tell you what the NSA will do or won't do. But the clients do have to take some responsibility, especially if they're in a proceeding. They're going to know that if they lie under oath, for example, or pass documents, there is always a risk. They also watch the news the same way as you do, and are going to be aware that people are watching. Again, though, you have protections in terms of how that data is used. So that's basically what I wanted to cover today. My goal in 10 minutes is to give you a broader idea of what technology is, what you need to be thinking about. When you get on an airplane, don't work on that document on your laptop that your neighbor next to you can see, for example, without a screen protector. These kind of things are really how security is breached, not a lot of the stuff you see on TV. And with that, I'll thank you for your attention, and I hope you follow my programs.